Hi everyone again. Happy Monday. So thank you all for taking your Monday afternoon to attend this webinar. Very happy to present the second episode of the AAA-ICDR Risk Management Toolkit. My name is Catherine Neo and I'm the moderator for episode 2, the intersection of disclosure and financing, Asian perspectives under the ICDR rules. So a quick introduction to the series if you're new to this. The intention of this whole series is to highlight how dispute resolution practitioners can consider risk management measures in a live dispute. Episode 2 particularly has a focus on the legal frameworks in each region governing third-party funding and insurance, as well as close-up examination of the ICDR rules in relation to disclosure. So I'll quickly introduce us the speakers and set the scene before the speakers, before we ask our esteemed panel some questions. So we have Chi Chong, who is an investment manager and senior legal counsel based in the Singapore office and of Omni Bridgeway. He's responsible for the strategic assessment and management of cross-border litigation, arbitration, and enforcement activities. Before joining Omni Bridgeway in 2019, Chi Chong practiced at Drew and Napier and the Singapore offices of Clyde & Co. and Holman Fenwick Willen, and he's admitted as a solicitor in England and Wales, as well as an advocate and solicitor in the High Court of Singapore. We also have Emmy, who is a partner in the dispute resolution team at Kudan & Partners in Thailand and heads up their Japan practice. So she has over 18 years of experience throughout Asia on complex commercial litigation, international arbitration, and fraud investigations. Emmy is a Hong Kong qualified lawyer. She's an accredited mediator and also on a panel of THAC, the list of arbitrators of HKIAC and EBRAM. We next have Adarsh, who is the Director of International Arbitration in Indian law firm Cyril Amachan Mangaldas. So he's based out of Singapore and is qualified to practice law in England and Wales as well as in India. We also have Crystal Wong, who is a partner of Lee Hishamuddin Allen & Gladhill in Malaysia. She is a prominent arbitration practitioner in Malaysia, Singapore, and the ASEAN region with a focus on energy, water supply, large infrastructure projects, and advises utility companies, as well as independent power producers. So we have Jack, who is a managing partner of Huizhong Law Firm, a leading dispute resolution law firm in China, and Jack specializes in cross-border litigation, international arbitration, and has successfully resolved disputes for numerous international companies. So before I go to each of the speakers, and as you can see from they're all very established with lots of experience in the region. But I wanted to first briefly set the scene for the relevant ICDR disclosure rule. So Rule 7 of the ICDR disclosure rule allows parties to apply or tribunals on their own initiative to require parties to disclose whether any non-party, for example, either a funder or an insurer, has undertaken to pay or to contribute to the cost of a party's participation in arbitration, and if so, identify the person or entity concerned and describe the nature of undertaking. The rule also requires, if the tribunal orders, any non-party which has an economic interest in the outcome of arbitration to disclose the same. So briefly in episode 1, on the insurance front, we spoke about after the event insurance, which covers adverse cost audit, as well as adverse judgment insurance and judgment preservation insurance, which ensures the outcome. So there are certain disputes where tribunals have ordered disclosure of details, especially when insurers have given certain undertakings, such as to make payment for adverse costs, for example, in a security for cost application. But strategically otherwise, if there has not been such an order, there are some parties who may opt to strategically disclose such backing, and that could show the merits of the case for negotiations. Well, now I've spoken for quite a bit, and it's time to hear from our experts. So before we hear from our regional experts on their local jurisdiction, Chi Chong, could you share with us, from a funding perspective, what are the key aspects to note in every arbitration in terms of disclosure obligations when it comes to funding?
Thanks, Catherine. I think as a matter of first principle, Omni Bridgeway as a third-party litigation funder, as a global third-party litigation funder, we have no issues with disclosure. In fact, our preference is actually to be disclosed as early an opportunity as possible, simply because of reasons of conflicts, which I will go into a bit later. And so this really is about disclosure in the context of arbitrations or also in litigations. But since we are talking before the AAA-ICDR audience, I think I'll focus my comments more on arbitration today. So most institutions like the ICDR have provisions in their rules, and Catherine's gone through them, that require the disclosure of the identity of the funder, their address, other details of the funder, and also provides tribunals with the power to compel parties to disclose other details of the funding relationship, such as whether adverse cost is covered or what the funder's financial interest is. And as I said, this is something that we, as a matter of principle, don't disagree with. And I think it's really in the devil in the details. And I'll explain a bit more shortly. And apart from these rules, institutional rules like the ICDR rules, some jurisdictions like Singapore and Hong Kong impose an obligation on the lawyers themselves to disclose if a case has been funded by a third-party funder. And so that's something that parties sometimes don't think about as well. And so this is something that's really, as a matter of first principle, is very important. And simply because, particularly in the arbitration context, you've got the issue of conflicts, right? So every time you appoint a tribunal, you've always got to consider whether the lawyers or the claimant themselves are conflicted with the tribunal, and there are certain guidelines that are applied across different jurisdictions on whether someone's in the red list or on the amber list, whether you can proceed to engage them. And really, the last thing you want to do after arbitrating or litigating a dispute for many, many years is to then, after winning and obtaining an award, have your award set aside or refuse recognition of, just simply because of conflicts issues. So at the first available opportunity, we would always want to disclose our involvement, because we would be then considered technically a party that has a commercial interest in the outcome of the arbitration. So that, I think, is quite established, and I think everybody agrees across different jurisdictions, across different types of legal systems as well. Of course, other reasons also justify disclosure, and I brought one up earlier, which is adverse cost. And for instance, if to the extent a plaintiff or claimant is impecunious and they are unable to pay any potential adverse cost, or at the end of the day, it's very important then to satisfy the counterparty to the arbitration, the respondent, that if they do succeed, so if the claimant fails, that there's someone that will cover any adverse costs. And typically, in I would say 90% of our funding contracts, unless the client doesn't want it, we will cover adverse costs. And so we would then disclose, okay, this is the extent of the adverse cost cover, and these are the circumstances in which we will pay the adverse costs. And so that gives the respondent some comfort. That also gives the tribunal some comfort as well. Now I'll turn to one last tricky issue before I'll hand it back to the rest. One thing that the AAA-ICDR rules and some other institutional rules also provide is that the tribunal can order that a party disclose the degree of the financial interest that the third party has. And in the context of funders, that's something that we sometimes don't want to be disclosed. And also from the claimant's perspective, they also don't want that to be disclosed. So for instance, if say our return is structured in a certain way that up to say 20 million is our returns, beyond 20 million, our returns are slightly lower, then that actually gives the respondent some sort of an anchor, and knowing that 20 million, maybe that's their settlement number, maybe we will be able to get them to settle at that number. So that actually, in that context, can be disadvantageous to claimants. So I think when it comes to that, kind of situation, we would discuss very, very seriously with our funded claimants, whether or not we disclose it and the extent to which we disclose it and what's the purpose of doing that. But one good thing about disclosing these financial interests sometimes is also that it puts the other side on notice. For instance, in some jurisdictions like England and in Singapore, it's possible to obtain the cost of funding. So if the plaintiff wins, you can say, oh, but for you, putting me into this position, having me to force me to get a third-party funder involved, I would not have been able to pursue this claim, and so therefore you should also bear my cost of funding. So that's something that also we can also we try to ask in most of our cases as well. Yeah, and I think in the insurance context, of course, the insurer doesn't want to let the other party know what the limits of their cover is, because that really gives away a big strategic advantage that the insurer has. So in that context, I think also I would imagine insurers also be very reluctant to share the extent of their financial interest as well. Yeah.
Yes, thanks so much, Chi Chong. You're exactly right. We do have insurers who have expressly upfront stating before they give a quote to the client that the agreement is that the details of the insurance agreement will not be shared, especially because that's where the amount at which insurance is paid out would really be the amount that's a good settlement negotiation as well, like what you have said. So now moving on to Crystal, let's talk about Malaysia. We understand that Malaysia has recently amended their arbitration law to allow for third-party funding. Can you share how this has impacted the funding landscape and parties' disclosure obligations?
Certainly. Thank you, Catherine. Indeed, Malaysia, we have recent amendments, and actually that's being rolled out by the Arbitration Amendment Bill 2024, and that is in July 2024. And then after that, in November 2024, we have just gazetted, so we're just waiting for it to come into force. So I can foresee shortly, I think either this month or next, the rules will be given and they will come into force, and obviously the Chapter 2 introduction of third-party funding will be applicable. In terms of, I personally think that the Malaysian arbitration practitioners are well aware of third-party funding, but the parties, I think, need to be updated about this feature itself. A little bit background why it come into place is that in, I think, on and about February 2024, our minister in the Prime Minister Department, the Law and Institutional Reform, made a public statement actually, and the public statement is in relation to consensus of the Malaysian government and the EU that the regulation of third-party funding should come into place, that is following the Sulu international arbitration saga. So that actually heightened the attention of the requirement of legalizing third-party funding. So that actually make fast track in terms of the introduction of third-party funding in Malaysia, and will do away for arbitration the rule against, the public policy issues pertaining to champati. So from that perspective, we see the introduction of our third-party funding in our act itself, and then slowly we'll be able to see more parties using it. Chi Chong just now mentioned about the requirement of disclosure. I think that is well covered under our act, our new sections. So the sections that I'm actually looking at is disclosure of information, section 46F itself. And that actually makes F and also the 46G. And I think those provisions sections are very good in the sense that it actually makes the funder disclose as a mandatory requirement for the funder to disclose and communicate to other parties to the arbitration and arbitral tribunal the existence of the third-party funding agreement itself. So I think that sets the foundation really well, and the timing of it would be, if I remember correctly, would be 14 days upon entering into the agreement itself. And of course, at the same time, you have to disclose the termination or end of this funding agreement. So from that perspective, I thought it's actually quite a good a way to allow or facilitate this necessity in terms of disclosure and to avoid potential conflict issue once you have commenced an arbitration. Other than that, I would like to share also in relation to a recent case, the 2024 case itself, about litigation funding agreement. I think this is something that Catherine and I, we were talking about this, I think in December or November, quite a bit. So sophistication in relation to usage of litigation funding in Malaysia, we haven't really seen that much. But I think slowly we probably will see more, because increasingly the court actually acknowledge, I wouldn't say they 100% support, but they acknowledge and accept fee sharing agreement, especially when there's base fees. So this particular case is called Hasina binti Mira Maidin, Tatuan Rajinda. So, and the case is actually in relation to funder paying the litigation costs upfront for the company, which lack funds, and the solicitor undertake to pay the funder a share of the judgment sum. So the High Court upheld the validity of the agreement letter, and the agreement letter is actually entered into between the funder and the solicitor. So it's a very interesting outcome that we've seen. I mean, and also the judgment itself is actually pretty well written. So this is something that I think in line with third-party funding that we've seen in arbitration, and slowly I believe we'll see more of this, more of the development in this direction. Yeah.
Thanks. Sorry, I was on mute. Thanks so much, Crystal. Really appreciate the very comprehensive perspective as well. Chi Chong, I think there was something you wanted to add about Malaysia as well.
Yeah, I think just wanted to just add to what Crystal said. I think it's the scene in Malaysia is still at its infancy, and I think there's quite a lot of aversion to third-party funding in Malaysia, simply because of the Sulu decision, the Sulu case, which was funded by another third-party funder, and something that we wouldn't have touched because there were so many issues with that case. And that sort of gave funders a bad name, but I think there is a growing need in the market that we've seen, quite a number of applications from Malaysian clients, and I think so this is something that we are very closely watching in this space. And I think the good thing is that I think now they've borrowed from the Malaysian legislation has borrowed from many of the best practices from many different jurisdictions now, and all the lessons learned in other jurisdictions, and I think that's a good foundation to develop that framework. Yeah.
Fantastic. And to add on in terms of insurance, right now there is not much legislation on that point as well in terms of disclosure and disputes, because really the area in litigation insurance is still very new in Malaysia as well. So we look to see how that space develops alongside funding. So on to you, Jack. We understand that China doesn't have a legal framework for insurance and third-party funding. So can you share with us a little bit more about what's the present position in China?
Of course, Catherine. In mainland China, the legal regime regarding third-party funding and insurance is still developing. So there is no formal rules regarding third-party funding. And third-party funding agreement generally are considered contracts, and they are subject to contract law. And in judicial practice, there are two leading judgments in the field of third-party funding. The first judgment was issued by Shanghai Court in 2021. In the Shanghai case, a party entered a third-party agreement with a funder and a law firm. They won, but the party refused to share the profit with the third-party funder. Then the third-party funder bring a litigation against the party before Shanghai Court. The Shanghai Court, however, finds the funding agreement to be invalid and unlawful because it violated public order and good customs. First, the Shanghai Court said that in the funding agreement, the law firm was controlled by the third-party funder, and the Shanghai Court is concerned that the law firm will put the interest of the third-party funder above the interest of the party. Second, the funding agreement in the Shanghai case limit the party's right to choose its own lawyer. And third, the funding agreement also limit the parties' freedom to make decisions in the arbitration. And most important of all, the Shanghai Court found that the funding agreement was not disclosed to the court or to the defendant in that case. So if there's any conflict of interest issue, the defendant and the court is not in a position to address the conflict of interest issue. Last, the Shanghai Court also found that the funding agreement encouraged litigation by reducing the financial burden of litigation, which is contrary to the public policy of encouraging settlement. It's fair to say that the Shanghai Court is quite skeptical of third-party funding, and the Shanghai judgment gives an impression that all funding agreements are invalid. But that's another judgment issued by Beijing Court in 2022, 1 year after the Shanghai judgment. In the Beijing case, a claimant in an arbitration entered a third-party funding agreement with a third-party funder. The claimant won the case, but this time, it was the respondent trying to set aside the arbitral award on the ground that, first, there's a conflict of interest issue between the arbitrator and the third-party funder. And second, participation of the third-party funder in the arbitration is a violation of the principle of confidentiality in arbitration. Beijing Court, however, refused to set aside the arbitral award because the Beijing Court found that there's no conflict of interest issue between the third-party funder and the arbitrator. And third-party funding won't make the arbitration public. And Beijing Court also went on to say that PRC law does not prohibit third-party funding, and a party in arbitration has the right to engage third-party funding in arbitration. Now, the question now we face is how to reconcile these two seemingly conflict judgments. I think it's fair to say that first, PRC Court will invalidate a funding agreement if this agreement violates public order and good customs. And second, PRC Court will not set aside an arbitral award simply because a party in the arbitration engaged in third-party funding. And PRC Court will probably decide the validity of a third-party funding agreement on a case-by-case basis. Factors will include whether there is separation between the funder and the law firm, whether the party will retain control in its right to choose the lawyer and making decisions in the arbitration, and whether the party would disclose the funding arrangement and the identity of the third-party funder to the tribunal and to other parties in a timely manner. After the Beijing court judgment, actually in China, a few arbitration bodies amend their rules to require a party to disclose the fact of the funding arrangement and the identity of the third-party funder. While the legal regime regarding third-party funding is developing in mainland China, in Hong Kong, however, third-party funding is clearly recognized and regulated by Chapter 609 of the Arbitration Ordinance. According to Chapter 609 of the Hong Kong Arbitration Ordinance, first, the third-party funding arrangement and the identity of the funder must be disclosed. Second, notice of the third-party funding must be given to each other party and the arbitration body. And last, notice must be given before commencement of the arbitration. And if the funding agreement is entered after the commencement of arbitration, the notice must be given within 15 days after the funding agreement is made. That's the legal regime in both mainland China and Hong Kong. Thank you, Catherine.
Thank you very much, Jack. Could you also elaborate a little bit about whether there's any framework in terms of insurance as well? Or would you say it's probably still very nascent and new?
Yeah, there's no legal framework in terms of insurance in mainland China. But in practice, when a party applies for freezing order in mainland China, it's quite often that this party will enter into an agreement with an insurance provider to ensure that in case the freezing order is not warranted, then it will be covered by insurance. Thank you, Catherine.
Thanks very much, Jack. And Chi Chong, I believe you were recently in China as well. So did you want to share a bit of insights from your experience?
Yeah, I think, I mean, one thing is that we do fund cases in China. And in fact, the second case that Jack talked about, the case that went before the Beijing 4th Intermediate Court, was a case that we funded. We funded an arbitration seated in Beijing. I think just to give a bit more context, and I think the Shanghai case as well is, from my understanding, was in the context of funding of a litigation.
Yes.
The validity of a funding agreement is something that's very important to us. It's not really important to the plaintiff itself, because
I think Chi Chong has his screen has hung.
the litigation will be a bit more
no, we cannot hear Chi Chong.
Okay. No worries. We'll get him back on the line and explain a little bit more. Sorry about that, everyone. Why don't we move on to Thailand? So Amy, what is the general position and attitude towards insurance and third-party funding in Thailand, and how would the disclosure obligations impact insurance and third-party funding? I know we had a discussion on this and wrote an article together last year, so very excited to hear your views.
Thank you, Catherine. Thank you for this opportunity to be on the panel to discuss this very interesting issue. I think to summarize very succinctly what the general attitude to litigation insurance and third-party funding is in Thailand, the word to describe it is curious. I think people are interested to hear more and learn more about litigation insurance as well as third-party funding. But the position in Thailand is, I would say, slightly sort of behind China, as we just heard from Jack, in that we don't have any formal legislation or regulation governing third-party funding or litigation insurance as yet. And I say that because Thailand has gone through quite a journey with arbitration. And recently, it has actually enacted various legislations to make it more arbitration friendly. So the background with third-party funding in Thailand is that Thailand is a civil law country. And so the common law doctrines of maintenance and champity, they do not apply in Thai law. However, there are regulations and legislations and Supreme Court cases which have made it very clear that allowing an unrelated third party to fund a litigation in return for benefit would be against public policy in Thailand. So when it comes to litigation funding, that would be the attitude of the courts as yet. However, those cases are not very recent. They were at least a decade ago, as far as I'm aware. So we don't have any recent cases or precedents that we can turn to in terms of the court's attitude. And I suppose the tricky situation with Thailand, and where it's a bit of a gray area, is that the Thai Civil and Commercial Code makes it very clear that you cannot claim restitution where the party has acted in a way that is contrary to the legal profession or good morals. So if litigation funding by an unrelated third party has not been permitted or not encouraged in Thailand, there is a risk for a third party funder if the funding agreement is breached and they want to somehow enforce the agreement within the Thai courts. We're just not sure how the courts will respond to that type of claim. And also in the context of enforcement of arbitral awards, where one of the parties have been funded, there is a question mark as to whether or not that award will be challenged on those grounds. But there is a but, and there is a positive slant to this, which is that, as I mentioned earlier, Thailand has gone through a journey with arbitration. And since about 2019, the Thai government has taken a lot of steps to be more arbitration friendly and has enacted legislation which enables foreign arbitrators and representatives to gain a work permit temporarily to come and arbitrate in Thailand. And so that was a significant change in stance by the Thai government. And there are things such as certificates that you can apply from the leading arbitral institutions in Thailand, which is the THAC and the TAI. And arbitral practitioners can also apply for what we call smart visas, which enable them to practice arbitration here. So there have been quite a lot of positive movements towards being pro-arbitration in Thailand. And also the Supreme Courts have been less intervening in arbitral proceedings and enforcing arbitral awards in Thailand. So I think the general movement is pro-arbitration in Thailand, and therefore Thailand looks very closely to what its neighboring jurisdictions are doing. So for example, with Singapore, because they have enacted legislation to support third-party funding, as well as Hong Kong, and now Malaysia, I'm glad to hear from Crystal the latest amendments to their arbitration ordinance to support third-party funding. I think it's a matter of time that the Thai government will be looking into how they might be able to support third-party funding and litigation insurance for arbitrations, at least as a start for arbitrations in Thailand. And in terms of disclosure rules, I do foresee that there may be frivolous challenges to arbitrators and challenges to enforcement of arbitral awards. Also requests for security for costs to delay process. Challenges to arbitrators are quite common in Thailand. And so putting third-party funding in the mix, I think that will be used as grounds to challenge arbitrators here. However, non-disclosure, on the other hand, will also increase the likelihood of challenges to arbitral awards in the future. So, I think the best way forward would be for any relevant legislation that will be enacted in Thailand to make it clear that the existing of a funding relationship shall not in itself constitute grounds for challenging an arbitrator or justify a request for security for costs here.
So much, Emmy, and I think I echo your views as well. This is probably we have to watch closely to see what happens in the neighboring regions. In terms of insurance, Thai practitioners have been particularly receptive as well, with even some of them considering litigation insurance for Thai domestic court proceedings as well. So I'll say watch this space. But to Chi Chong, sorry that you dropped off a little bit earlier. Would you want to share a little bit more about your thoughts on Thailand?
Yeah, I think it's very similar to, the Thai position is a bit slower than the Malaysian position, I guess. And so I think from our perspective, we would be a bit more cautious when it comes to funding of arbitration seated in Thailand or governed by the Thai arbitration institutions, because there's a bit of uncertainty there whether we can fund. Having said that, we have funded cases for and against Thai parties, but they have all been seated outside Thailand. So I think it's a space that I will very closely watch, given the lack of clarity in the Thai rules. Yeah.
Thanks so much, Chi Chong. And on to Adarsh. We understand that in general the Indian courts do acknowledge funding, but there are no formal guidelines or rules relating to it. So as regards insurance, India is also quite new to the space. So how do you see the growth of the funding and insurance markets in light of the developments there?
Sure. Thank you, Catherine. So as far as third-party funding is concerned, I think the good news is that despite India being a common law country, the doctrines of champerty and maintenance, which under English law, they don't really apply in India. And this has been the position for over a century. So the only really obstacle or test that a funding arrangement needs to clear is the test of public policy. And over time, there have been instances where certain funding arrangements have been found to be opposed to public policy. For instance, a lawyer funding their client's dispute is an absolute no-go. As legal professionals in India, we are not even allowed to charge contingency fees, and funding the client's dispute is out of the question. But other than that, the test that courts normally apply is that as long as the agreement is not extortionate or unconscionable and provides the funder with excessive control over the proceedings, the agreement will be upheld. So what is an excessive share in the outcome is actually something that differs from case to case. There have been instances where a 40% share of the proceeds has been held to be extortionist, but up to 75% has also been held to be unenforceable. As far as disclosure goes, I'd first refer to the litigation funding aspect of it, because there isn't really much in terms of arbitration, other than the fact that an arbitrator who has a close relationship with a party who has recourse to the proceeds of an award is ineligible. So beyond that, there isn't really something. From this, we infer that you would have to disclose if a party has any recourse to the proceeds. Otherwise, how would the arbitrator be able to disclose, and hence how would you know that they are ineligible? But for litigation funding, there are some states which have amended the Civil Procedure Code in different ways to account for the fact that when a party is financed by a non-party, then in some states, it's mandatory to order security for costs. And in some other states, the court is actually empowered to implead the funder as a party to the proceedings. Now, this can either be done with the consent of the funder, in which case the funder will be the plaintiff, or without the consent of the funder, in which case they would be a defendant. But in both these cases, the court can then direct the funder to provide security for costs. And if they don't do so, then the court will rule that they will not have any interest or share in any proceeds of the litigation. So this is the framework when it comes to litigation, but there is no equivalent provision for arbitration. And apart from that reference in the disclosure in the ineligibility requirements for arbitrators, the arbitration landscape has really not been regulated. Recently, we had a case before one of the high courts where a funding arrangement was disclosed in the arbitration. The respondent applied for security for costs in the arbitration, and the tribunal found that it was not necessary. Ultimately, the claimant lost the arbitration, and the respondents had an adverse cost order in their favor. When they sought to enforce that, they found that the claimants are insolvent. So they tried to get the court to order the funder to provide and satisfy the adverse costs order. But the court went into the details of the arrangement and said that, look, the funding arrangement does not provide for an adverse cost order, and hence we will not order it, right? So this has been taken to be quite an encouraging sign that the court will actually uphold and respect what has been agreed between the funder and the party. But I must put a caveat here that this is currently under appeal to our Supreme Court, and so we are going to watch and see what happens, whether the same outcome is maintained. Because before the court of first instance, actually the funder had been asked to provide for the adverse cost order, and it was only in appeal that the High Court actually said, no, we should respect the funding agreement. So as far as the trends are concerned, traditionally, most funders have been hesitant to fund claims in India because there are uncertainties regarding the timelines for upholding arbitral awards, and there's a risk that in the meantime, assets get dissipated. But since 2015, our arbitration law was amended where the party who's challenging an award has to actually deposit the money in court as a condition for a stay of enforcement. So this should provide considerable comfort. And claims by Indian entities against foreign parties are often what we find funders are quite interested in funding. And this is because the enforcement risks where the counterparty is located are probably much lower than the enforcement risks in India. The insolvency regime in India is another area where there are a lot of funding opportunities because the companies that are under the equivalent of judicial management in Singapore, it's called insolvency resolution. So there's a committee of creditors and a resolution professional who's in charge of the company to try and revive it. They usually don't want to put more money into pursuing a claim. But last year, there was a $1.5 billion claim by one such company against an overseas party, which was actually funded. And reportedly, at least 20 million USD is the amount of funding that has already been sort of disbursed. So that came as quite a good signal that the Indian market is ready to look at funding more closely. You know, to get a committee of public sector banks to agree to something was, I think, a big step. Normally, they're quite conservative when it comes to this. While funding is primarily for claimants, I think defendants have increasingly become aware of litigation risk insurance as well, especially adverse judgment insurance. I understand that in tax matters, sometimes this is quite prevalent. But in terms of the future, I do think that it's a combination of funding and insurance that is likely to work well. Funding for the claim, and once you get an award while it is under challenge, judgment preservation insurance is likely to be the formula going forward. The other advantage is that as far as insurance is concerned, the entire framework that I spoke about earlier about disclosure is not yet ripe in India. While funders have been recognized as you might have to disclose because you're financing the litigation, no such requirement is there for insurance as of now. As and when, if there are institutional arbitration rules which provide for it and which govern the arbitration agreement, that's where those requirements may come from. So that's it from me. Thank you, Catherine. Catherine, you're on mute.
Sorry, thanks so much for telling me I've been speaking without anyone. Yes, so thanks so much for sharing. I think it's very comprehensive, and you're correct that in fact for insurance there's no such disclosure requirements. But under the AAA-ICDR rules, it is possible that a tribunal may still order if it is applied by one of the parties or on their own initiatives as well. On that note, we had a question from one of the participants earlier who asked for the reference to the AAA-ICDR rules and disclosure obligation. So that's in Article 14. So I'll have a look at that. So Chishong wanted to, would you like to share any views on India as well?
Yeah, I think I think the Indian market's a bit more developed, and so something that we've looked at. We've funded cases against Indian parties. We have also funded Indian court litigation in the past. But I think duration risk is something that's of a bit of a concern for us, given how long proceedings can take in India, and how sometimes parties tend to take every potential interlocutory application so that you can drag out this period for as long as possible. I'll be very interested to see the outcome of that case that you're talking about that's going to appeal on, or going on appeal to the Supreme Court. And I think generally, as a matter of principle, third-party funders do not submit to the jurisdiction of the tribunal. And so therefore, the tribunal doesn't actually have powers to order costs against the third-party funder. However, if there's security for costs that's at play or adverse cost orders, and there's an undertaking by the funder to do that, that's a bilateral agreement that they enter into with the respondent. So actually, the tribunal doesn't have the power to grant that. So I'll be interested to see what's the basis. I mean, what the basis of the first instance court for the court to say that the third-party funder should cover the cost, and how maybe the Supreme Court does resolve that issue in due course. I know there is English case law, and I did this when I was back in practice, where the English courts have actually ordered that a third party bear the cost, the cost of a litigation. But that's only in the very limited context where the third party has submitted to jurisdiction because they are in effect the controlling mind of the party in dispute. So I think that boils down back to the issue of how much control does the funder have, And in most of our contracts, and particularly in common law jurisdictions, we can't have control. So ultimately, save for certain established grounds like settlement, that's something that we needs to be jointly agreed. So we can't have control, and so therefore we can't be the directing mind controlling the arbitration. Therefore, we can't be the one that's that is liable for the adverse cost unless we've already agreed to the adverse cost. Yeah.
Thanks so much, Chi Chong. And we've got such a good sharing with all our audiences from different perspectives. We do have a question from the floor, which was asking about Jack's cases. They would like to know the names of the cases referred to by you, Jack. And maybe Chi Chong, where you dropped off just now, you might want to add on as well. So maybe Jack first. You're on mute at the moment.
Sorry. Let me check the name of the case. Actually, I have the two cases right before me. The first case, the Beijing case is a case between Dong Leichen and it's a Chinese name, and then National Bank and Aviation Rental Company. And the case number is 2022 Jing 04 and Ming Te 36A. And the second case, the Shanghai case, the name of the parties are not disclosed in the judgment, but the case number is disclosed. The case number is 2021 Hu 02 Mingzhong 10224. I think it's pretty easy to find these two leading cases in China regarding third-party funding because there are only two cases in China. Xie.
Yeah, I think you can find it if you just Google third-party funding cases in China, these two cases will come up. So the first one is Shanghai Second Intermediate People's Court. And I think I don't know where I got cut off earlier, but I was saying that was in the context of litigation. In the other case, it was a case of a Beijing seated arbitration, domestic arbitration that we funded. And so I was very close to the facts of the case, and we were very well disclosed at the start of the case as well. We made sure that conflicts were not an issue, and I think the respondent just tried to come up with many different types of ways to say that that one of our shareholders used to be advised by one of the tribunal's firms, which really was the most absurd thing, because actually the shareholder that was involved was actually HSBC nominees. So someone else was holding shares in the company through HSBC. And then they say, oh, just because this tribunal member's firm had advised HSBC at one point of time, therefore they are conflicted. So obviously that was rejected at the arbitration stage, and therefore when it went before the Beijing Fourth Intermediate Court, it was also rejected. The other point of confidentiality, I think, also raises some things for consideration for people here. Is that in that case, what happened was that they said, oh, you're breaching confidentiality by letting a third party know about the contents of our case, right, or of our dispute with you. There's a confidentiality clause in our agreement. This was obviously rejected by the tribunal as well, and that's why on appeal it was also rejected at the set-aside stage. And the rationale was that most contracts provide that a party, whilst they are bound by confidentiality, there are exceptions to the confidentiality, including to seek advice from your lawyers, to get to disclose this information to your accountants, to your financiers, or your other advisors. And so we relied on the financiers or other advisors exception in the confidential clause in that agreement. And so so that confidentiality argument, breach of confidentiality argument, was rejected by the court, by the tribunal, and then subsequently by the court. I think it's very, very important to understand the context of that. And from our perspective, I think what Jack said earlier about ensuring that the funder does not have control, that the funder is disclosed at the earliest possible opportunity to ensure that there's no conflict. I think that's something that we practice as a matter of first principle, and so I think that's something that we will be very careful to do particularly given the Shanghai Second Intermediate Court decision. Yeah.
Yeah, Qi-Chung. I think another distinction between the Shanghai case and the Beijing case is that in the Beijing case, the party disclosed the third-party funding arrangement and the identity of the third-party funder to the tribunal and to the other party. And that's I think that's the right thing to do. And I think that's also one of the reasons in the set-aside proceeding, the Beijing court upheld the validity of the third-party funding agreement. Okay, then we come to agreement.
Yeah, of course.
Thanks so much, Jack and Chi-Chong. Very, very interesting insight as well. Now we have about 8 minutes left. I will try not to go beyond the time. We usually have, as the last part of the webinar, a quick fire round of questions for all our guest speakers. So this means that we'll ask them a question and they have to answer sometimes in a sentence or less than 10 words. And usually it doesn't really relate completely to whatever that's on point, but really to give you a different perspective of the arbitration industry or their own personal thoughts on arbitration as well. So Chi-Chong, I'll start with you, even though you just spoke. In less than 10 words, name one thing you absolutely cannot do in third-party funding.
Well, we pretty much do everything, but the one thing we really will not do is we won't fund a case against sanctioned parties because we won't be able to recover money from them. Yeah.
Right, thanks very much, Chi-Chong. Actually, that's the same in insurance as well. We can't insure sanctioned parties as well. Well, Crystal, next up is you. In one sentence, what is a trend that you hope will dominate the arbitration space in Malaysia in the next 5 years?
Okay, 2 sentences. In effect, next 5 years, since I'm an energy practitioner, so I hope to see a stronger focus on transparency and accountability in ESG related matter within Malaysia arbitration space. And with the rise of greenwashing, there will be more dispute, and I do hope that third-party funding can enable the supporting claimants who seeks to hold companies accountable to these misleading ESG claims through arbitration.
Right, thanks very much, Crystal. And Jack, next up is you. What is one surprising fact that people do not usually know about the Chinese arbitration landscape?
In arbitration in China, it's unbelievably easy to obtain a freezing order.
Oh, wow. I would wish that you have more time to elaborate on that. That would be quite interesting to hear. So maybe we can reserve that for a second session to hear more from you.
Okay. Actually, in my
can-
career, I have never failed to obtain a freezing order for my client.
Wow, fantastic. And I would really love to hear it offline. What's
Okay.
the reason for that? Thank you so much. And Emmy, if you had a superpower, what is one thing you would do to change the arbitration industry?
Thank you, Catherine. I'm very pleased to get this question because I just watched a Marvel film over the weekend. But I think if I had a superpower, the one thing I would change is to make arbitration more accessible. So whether that is making it more efficient or cheaper for parties or making it more diverse. And so we could promote more access to justice. So I kind of cheated there. I put in a lot of factors in, but the main word is accessibility.
Fantastic. Thanks so much. And finally, Adash, in one sentence, describe how you would like an ideal party to behave in an arbitration. Of course, not all parties will behave ideally. So.
And I think I have a very long list, but since you've restricted me to one sentence, I'd say I'd like them to behave how they want their counterparty to behave. I think that's a very good test to go by.
Wow, very interesting. All right. So let's see if we've got any more questions. For the rest of you who are are here, we have another 2 more minutes for questions. So please feel free to send in your questions. But if not, we will wait for another minute to see if there's any further questions from the floor. But thank you so much, everyone, for attending. I'll just wait for a minute, see if there are questions. I think we're good. So we're good to go. Thank you so much to our distinguished panelists for taking the time today on a Monday afternoon to speak with all of us. And thank you so much for the attendees for taking the time as well. Please feel free to reach out to us either on LinkedIn, by email, if you have any questions you want to ask about whatever that's been discussed. Thank you, everyone.
Thank you.
Thank you,
Bye.
everyone. Happy New Year.
Happy New Year.
Happy New Year.
Happy New Year.